Okay. And then I have let's see, Jeremiah Cummings. And that's the one that you wanted us to revisit probable cause on. It's the deadly conduct.
Let's take a moment to break this down. In Texas, deadly conduct doesn't always mean someone is firing a gun. Sometimes just showing a firearm in a reckless or unsafe way can be enough to raise legal concerns. But what exactly counts as reckless? That's where things start to get...
Pulled out a weapon. He didn't brandish it. I mean, he didn't point it at the complaining witness. I think the chief is going to look something up, but I can come back on that, I guess. Okay.
Is that it?
Those are the only three I have. All right. So, yes. And then I'm going to go check on her.
Back again, Judge. Okay.
complicated. Now we're back to Mr. Cummings, the main figure in this case. It's important to note, no shots were fired. The issue here is whether holding a gun during an argument is considered a threat, or just poor judgment in the heat of the moment.
Guess who's back? Back again.
I missed it already.
Guess who's back?
He's done, right? Yeah.
We're approaching on Mr. Jeremiah Cummings. That's the one about the deadly conduct.
I don't remember. I mean, I don't remember what happened for breakfast, so you're gonna have to refresh my memory. What happened?
Then there's the moment someone says, "Shoot me, shoot me." That's a serious statement, but how should it be interpreted? Is it a sign of emotional distress, a provocation, or something that changes the legal risk? Judges look at more than just the words. They consider how it was said, what was happening at the time.
Yes, sir. I'll just read the summary. On April 11, 2025, in Harris County, Texas, an officer was dispatched to a family disturbance call and met with the complaining witness. The complaining witness said that an argument occurred between her and the defendant, and that the defendant grabbed his handgun and held it.
And whether it seemed threatening. One smart question came from the judge. Where's the line between an argument and a crime? If someone is holding a gun but not making direct threats, does that still break the law? What do you think? Share your thoughts in the comments.
Returned to the apartment and contacted the sheriff's office to report the incident. When the officer approached the defendant, he stated, "I'm not talking, I'll answer questions." Gathered his things and grabbed a handgun and placed it in his pants. The officer then drew a weapon and said, shoot me then. The deadly conduct, Your Honor, is alleged based on the fact that the defendant was holding the gun during the argument with the complaining witness.
Does that mean that if anyone ever gets into an argument and has a gun in their hand, that they're literally, I mean, theoretically guilty of a deadly conduct just by virtue of, and then what kind of argument can it be? What level of discourse must there be for someone to be, you know?
Right, and
That can't be the law.
Talk about this one where it's not a terrorist figure or an hacksaw, nothing really said. It was like the point is, we have also spoken.
So, I mean, think about this. Like, let's say you and I are arguing, right? And I'm mad at you, and I just, I get the gun just to put it somewhere else,
Right. I get it. And I mean, wasn't charged as an ag. Because
I get it, but
we have spoken to the complainant. I think I remember last time with this case, you wanted to hear from the complainant, just before you made a PC.
you have anything else?
She's not, from what we can see, she's not. She wants to be around him. She said he had a gun.
Is he here?
No,
He's not
he
here?
waived his appearance.
Right. I remember. Yeah. All right. I'm going to find no problem.
All right.